My name is Jay Chauhan. I'm a lawyer practicing for 40 years in Richmond Hill, and I'm also a deputy judge for 20 years in this town, Richmond Hill, Ontario, Canada. And this video is prepared to prepare somebody without experience to try to prepare him for a trial in the smoke claims court, where many people today attempt to represent themselves. So this video is a very practical video on how you should prepare yourself for a trial in the smoke claims court. So I have Ilan here, and he will ask the questions, and he wants to prepare for a trial. So Ilan, so tell me the questions that go through your mind in preparing for a trial in the smoke claims court.
Well, first of all, what types of legal matters are normally taken to the smoke claims court?
Well, just about most questions in civil law that are under the amount of $25,000 can be taken to smoke claims court. There are very few exceptions, such as the special remedies, mandamus, and so on, bankruptcy, landlord-tenant tribunals, issues which cannot be taken to smoke claims court. But apart from that, most matters like toll contract issues can be taken to the smoke claims court.
Right, and you said that it was for matters about underneath $25,000. Let's say I have a matter for $30,000. Can I still take it there?
You can, Ilan, still take it there, and the way to do it is to say in the pleadings or the claim that any amount which is over $25,000 you're prepared to waive, and only forget that, and that will bring the claim within the jurisdiction of the smoke claims court, so you can still bring it there.
All right. Should I have a lawyer going into the smoke claims court?
If you can afford a lawyer, it is preferable, because lawyer, like a doctor, is there very well trained in presenting your position. But what my observation as a judge and a lawyer is that for the cost of the lawyer, between $250 to $300 an hour, it becomes very expensive for an average citizen to take a lawyer to the court. So what we have in the last few years in Ontario is a paralegal who is also trained and is registered with the Law Society, who can also represent you in the smoke claims court.
Excellent. Well, how would I prepare any documents for the smoke claims court?
Well, firstly, in terms of the claim that you prepare, you can attach the key documents that you have right to the claim itself that permits the court as well as the opposing party to know your position. Those documents that you've not attached can also be brought into the trial situation by the settlement conference stage, by giving the documents to the opposing party and also the court office. And those which you have still not given should be given to the opposing party in the court by providing these documents in a final bundle to the court office and the opposing party about a month before the date of trial.
Mm-hmm. And other than these documents, what else should be prepared and presented before the court, before this actual trial?
Well, you should also have a list of the witnesses that you should prepare and provide it to the opposing party, and that list enables you to prepare and the opposing party to prepare for their witnesses, and that should also be provided a month before the date of the trial.
Mm-hmm. So, into the actual trial, how does one normally begin?
The trial begins with the opening statement of the plaintiff lawyer or paralegal or the plaintiff himself. And after the summary of the case is presented, then the opposing party makes an opening remark. And I should point out that at this stage, many people make the common mistake of narrating their entire story at this time. It is not necessary and it should not be done. The opening statement is simply a summary of what your legal position is and a summary of the evidence that you will present. So it gives the judge an idea in his mind what is the nature of the trial that is going to conduct for you.
Mm-hmm. What comes next after these opening remarks?
Well, the next thing is that the witnesses of the plaintiff will be presented one at a time. And after the witness has presented his evidence with the questions from the plaintiff, then the opposing party has a right to cross-examine, which means to ask questions. And in the cross-examination, I should point out there again that you should pinpoint the essential issues and not attempt to rehash the entire set of evidence that you want to present through the cross-examination. So it is simply to emphasize and obtain admissions from the witness as to your position from your point of view.
All right. How would I ask questions to my own witnesses that I have?
A better way to ask questions to your own witness is not to ask what I call leading questions. Leading questions are those where you indirectly suggest the answer to the witness. Did you not go on this particular day and do this particular thing? That kind of a question is leading, but it is better to ask question that is a little bit what I call open-ended. What did you do on this particular day? And let the witness then describe what he saw or what he did, which will narrate his evidence.
In what order will witnesses normally be examined?
There is no particular order prescribed, but I think it is a question of the plaintiff or the defendant deciding the sequence in which you want to call the witnesses. The best sequence, in my experience, is the sequence in which the events happen. So it makes a logical story in the mind of the judge. And you have to keep in mind that the whole trial, what you're aiming at is showing your position to the judge so that it makes sense from the point of view of the law and the witnesses that support your position. So it is the judge that you're aiming at in terms of how you present your witnesses, in the sequence in which you present them, so that you can make your position clear to the court as best as you can.
Mm-hmm. And how would I choose my witnesses? What should I look for when I'm choosing my witnesses?
Well, firstly, you have to identify what is called the cause of action. For example, let me take two examples. One is in contract, one is in tort. Is that the common law claims that are often brought in the small claims court. In a contract situation, you want to be able to illustrate and show to the court that you had a good agreement, which is a contract, and the evidence is presented to make sure that the witness is able to show the contract did exist, and that the work done pursuant to the contract was also done by you as you're the plaintiff, and therefore you're looking for the money to be paid from the defendant. If it is a tort action, you want to be able to describe what happened in terms of what went wrong and the injury took place. So there is an element of proving that the fact happened or event happened which caused the injury, the extent of injury, and therefore the amount of damages in both cases, in contract or tort, that you suffered, which is what you're asking the court to give to you as a plaintiff.
It is my understanding that there's an examination process and a cross-examination process during the questioning of witnesses. How can I examine my witnesses effectively?
Well, in the examination, you ask questions, so the witness is answering questions to present your position. In cross-examination, you're trying to ask the opposite party's witnesses the questions that you want to ask to illustrate, again, the points that you want to emphasize from your point of view and your position point of view, because there are always two sides to the story, and in the cross-examination, you want to emphasize your position.
But what if I believe that a witness is responding untruthfully?
It's not, from my experience, it's not very often common for parties to deliberately tell a lie. I think it is the parties are under oath, and at the beginning of the witness's testimony, they are administered an oath. And I think where you do feel strongly that the witness may not be giving truthful evidence, then you can remind him that he's required to tell the truth, and if he did not, then a false statement constitutes perjury, which is a criminal offense. So that is the incentive the witness should have to make sure that he is telling the truth.
Mm-hmm. how is a trial concluded after all of these steps during it?
So just to summarize, actually, you had the opening statement, witnesses of the plaintiff first presented one at a time, and then there was cross-examination of each witness, and then the witnesses of the defendant, and the cross-examination of each of the defendant's witnesses by the plaintiff. Then comes the summary. In the summary, it is important and helpful if you do not repeat the entire evidence, because the judge has heard it. What is important at that time is you summarize and emphasize what has been shown from your point of view, either as a plaintiff or as a defendant, your position. So it's a summary of your, what I call a cause of action, or it may be a reason for the claim being brought, and how it was illustrated by the evidence that you presented. And this is a good opportunity to try to comment on the weaknesses of the opposing party's evidence. And that is the summary. It is not a situation where you rehash the evidence and tell the whole story over again.
But how does it differ from the opening statements that we had?
The opening statement is only your position. At that time, you did not have the opportunity to understand the full impact of the evidence of the opposing party. So in the closing statement, you're able to comment on the evidence of the opposing party and point out the fact that your evidence was better and more supportive of your cause of action or the defense, whatever it may be.
Very true. How does the judge make his or her decision at the end?
Well, in a small claims court, the judges will always provide reasons for the judgment, and these reasons may be oral, and if the judge decides to give it in writing, then he will reserve the judgment, and then he will write a judgment which will be sent to the court office, and the court office will then mail it to you.
And then who is responsible for carrying out this judgment that occurs?
The judgment is then carried out by the plaintiff's own initiative. So the judgment is a summary of the liability of the defendant to make a payment, but the fact of when and how he pays is not a part of that process. Therefore, the plaintiff must take the initiative by way of different things that they can do as a plaintiff to collect on the judgment, which includes a garnishee order, what is called an execution, or sending a bailiff and collect the money from the defendant, or a judgment summons examination, which is the way by which you can call the defendant and ask questions on the assets and in his ability to make payments, and ask the judge to require him to make those payments. So that what I call collection proceeding after judgment is separate and different from the trial judgment, which simply concludes whether or not the payment is due.
And once this judgment occurs, is it set in stone? Do I have any option to disagree with it?
Well, one option you have is to appeal it. I think if the amount of your claim is more than $500, then you have a right to appeal this case to a higher court. So appeal is always possible, and it can be done so that you can have the judgment reviewed by another court if you disagree with it.
Excellent. Do you have any other pieces of advice that would be helpful for me?
Well, I think the best way to prepare, and this is advice to many people who today go to the court on their own, and that is that it is very helpful to prepare for the trial, and the preparation can be done by way of listing the questions as you've done here, Ilan, and those questions rehearsed in your mind a couple of times. If you can go to the court, sit in hearings and see how the court feels and looks, so that you're not intimidated at the time when the trial comes. If you've done it a couple of times, then it becomes easier, because the courtroom is a slightly intimidating environment. It's very important that you have rehearsed it so that you are able to present your position confidently and then also more accurately, so that you get that judgment in your favor. So that's my advice.
Great, thank you very much.
Thank you, Ilan.